Welcome to Aging Insight with your host, John Ross and Lisa Scholmeyer. This program is made possible by
Well, welcome back to Aging Insight. I'm Lisa Scholmeyer, and I'm here today with John Ross. And you're watching the program that brings you information about legal needs, financial matters, health and housing matters that all impact you as a retiree, a senior, or maybe a future retiree or senior. So that's what this program is about, is to bring you that information.
Yeah, there's so many different pieces to these puzzles. There's issues related to as you age, there's issues related to the people you leave behind, but then there's also a whole set of issues related to the transfers of property at death, and all of these things combined together. And really, if your goals are to maintain your independence and avoid being a burden on others and protect and preserve the resources that you've accumulated during your lifetime, whether for your own benefit or for the benefit of your heirs, it's important that you know how this whole little path works, not just from here to the end of your life, but from here and beyond.
And beyond, yeah, sure. John, this past couple of weeks, I've had a lot of questions about alternatives to probate. And I've had a lot of folks come in and they have maybe lost a family member or loved one, and there is property out there that was owned by that loved one that's now gone, and it might be a bank account, a homestead, or a residence. It might be investment accounts or stocks and bonds. And a lot of folks, they come in, John, and they always say, or frequently they say, my family member was not a wealthy person.
Right.
So what can we do to get these assets transferred to the heirs and beneficiaries? Are there ways to do that besides a probate process? Because what I've learned is, well, I guess, John, first, what is probate?
Right. And so, for example, I had some clients call earlier, and they're really their mother's only asset. She had some bank accounts and things, but she had beneficiaries listed on those accounts, so those had already transferred. But there was also a safety deposit box, and the bank had told the family, oh, you just need to go get some letters from the court and then bring those back, and then we can give you the safety deposit box. And so they called me and said, hey, can you help us get these letters? I mean, it seems like a pretty easy little deal. Well, it's not really that easy, because what they're talking about are letters of administration or letters testamentary, depending on whether the person died with a will or without a will. But in any case, this is stuff that is issued by the court during the probate process. And essentially what that probate process is if they have a will, it's filing the will with the court, having a hearing. If they don't have a will, then it's filing with the court to determine who their heirs are. And at the conclusion of that hearing, you have a person appointed who's in charge of the estate. That would be the executor or administrator. That person then has to file an inventory of the estate. They have to publish notice to creditors. They have to provide notice to beneficiaries. And there's a whole lot of different things that have to go on in a process that can take anywhere from several weeks to several months. And throughout this process, you have attorney fees, you have court costs, you have publication costs for the newspaper, and a number of other fees, all of which can easily add up into a few $1,000s on the low end. And after explaining all of that to the family, they're like, but we just wanted to get in the safety deposit box.
Right. We just, and so that's when the question becomes, is there any other way? Is there any alternative to this probate process that you have described to them, which sounds like it takes a while. It sounds like there's a lot of people involved, a lot of hands in the cookie jar, so to speak.
That's right.
So a lot of folks are very interested in if there are probate alternatives. And, today, John, I want to talk about probate alternatives after someone has passed away.
Right.
There
there's certainly lots of things that could have been done before the person died.
yes.
I mentioned like the bank accounts, and if you've got people named as beneficiaries, that goes directly to the beneficiaries. If you've done a ladybird deed, for example, on the house, which we've talked about on another program, that might pass outside of probate. If you've used a trust, which we've talked a lot about on the program, trust assets also pass out. So there's ways, but so often nobody ever took advantage of those.
Right, and once a person has passed away, our options are a little bit more limited. And so I think what we'll do is we'll come back, we'll take our break now, but when we come back, we'll start talking about those alternatives to a full probate process, which you may be aware of, and we'll discuss those and talk about the situations that those alternatives to probate, when they work. So we'll be right back.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
Welcome back to Aging Insight, everybody. I'm John Ross here with Lisa Scholmeyer, and today we're talking about probate alternatives, because so often after somebody has died, you run into an impediment where you're trying to transfer title, say, to a piece of real estate, you're trying to access a bank account, or you're trying to get into a safety deposit box or some other asset or situation out there that, because the person who owned that bank account or that house is no longer with us, there's nobody who has the legal authority to deal with those properties. And when people run into these problems, they often find out that, well, yeah, there's the traditional probate process, but that process is long, expensive, time consuming, and they want to say, well, geez, there's got to be another solution. In fact, these people have many of the people who have been through this have complained about this to their respective legislators and things like that. And so there have been some probate alternatives that have developed over the years. So we're going to start by kind of talking about some of those and what they look like and what they are.
Right. So, one of the first things that the family situation we need to figure out is, did the deceased person leave a will or not? Because certain probate alternatives or shortcut probate procedures are available depending on whether a will exists or not. So that's the first question. Is there a will? Now, if there is not a will, so no one in the family is aware of a last will and testament by the deceased, the deceased there's no will located with the important papers of the deceased. In that case, we can go forward presuming that there was no will, and under both Texas and Arkansas law, there is a probate alternative in this situation, and it is referred to as a small estate affidavit, presuming that the deceased was in fact a person of quite modest modest wealth. In Texas, you can use a small estate affidavit in the situation where a deceased person did not have a will and had $50,000 or less in personal property and other property excluding their homestead. So if they just had a homestead, we don't have to count the value of that to see if we can use the small estate affidavit. So outside of the homestead, if everything else owned by the deceased was worth less than $50,000 in the state of Texas, then we may be able to use a small estate affidavit. Now in Arkansas, we have a bit more leeway. In Arkansas, we can use a small estate affidavit if the deceased estate is worth $100,000 or less, excluding homestead. So, you know, John, that covers quite a few people that we visit with or that I see, you know, on a somewhat regular basis. Oftentimes, people have expended quite a few of their assets in their later years for their care needs. Sure. And so at the time of their death, they may have a home and, you know, a CD or two at the bank, and it's
relatively modest.
Yes.
Yeah, and so this can be a useful tool because you're not having to go through quite as much rigmarole in all of this. You're talking about a document that's going to line out who the person was, for example, when they were born, when they died, who they were married to during their marriage, what children they had, so who their heirs are. But you know, that sometimes can be confusing for families when they're trying to fill these sort of things out. You know, figuring out who the heirs are. And I remember having one family and you know, it was two brothers, and they came in and they said, well, you know, mom's died, we're thinking about doing this affidavit here, and we're the only two heirs. And I said, oh, okay, well, so mom didn't have any other brothers and sisters? Oh, well, yeah, she had 3 other kids, but they're all dead.
Right.
Well, but did they have children? Well, yes, they did. So yeah, no, you two are, so you in order to do this, you do have to have a thorough understanding of who a person's heirs are.
Well, that's right, and you have to know who those family members are. And also, when we've looked at using a small estate affidavit, occasionally I'll have a family member say, well, you know, I did have my brother, but mom hasn't talked to my brother in 20 plus years, and so she never intended for my brother to receive anything from her estate. Well, you know, in this situation, what mom may have intended or may have verbally said to someone has no legal effect whatsoever. So, you know, if we don't have a will, then the courts are looking to see who the natural heirs of the deceased are, and there's really no variation, there's no variance from that list. So we need to know who the family members are, and they're all going to have to be listed, children, and then of course perhaps grandchildren if children are already deceased. So, you know, John, another part of the information that can be difficult for families to come up with is a listing of the property and debts of the deceased.
Right, which they may or may not even know about. That may be part of the deal, is they're trying to find out what information is out there, like where did they bank, what investments do they have, things like that. And they're wanting to get that information, but they don't have the power to get that information.
Right, and so really a small estate affidavit is not a good probate alternative to use if you are completely in the dark about what the deceased properties and debts may have been. You know, a lot of times if you look through the deceased papers, bank statements, bills, you can determine quite a bit. And of course, a lot of times children who've been caring for an aging parent, they know quite a bit about what's going
Oftentimes,
on.
That's right. But that's not the only issue you have in here, because the other part is the nature of the property that you're dealing with. For example, if you live in a small Arkansas community where everybody knows everybody, you know, doing something like a small estate affidavit to transfer title to a piece of real estate, say to, you know, 2 brothers and sisters, you know, mom's died, and you're going to transfer the title of that house to brother and sister, son and daughter, who get along wonderfully, and you know, that might be fine. On the other hand, if, for example, mom had a CD at a bank, that bank was a national bank, like a Bank of America or something
Yeah.
like that, Bank of America is going to be headquartered in New York City or
Right.
someplace, Chicago or something like that.
Yeah, they're branch in Foreman, Arkansas. They're not going to know.
And and so unfortunately, when you bring these state level probate alternatives like a small estate affidavit to a big bank, that document then ends up getting reviewed by attorneys in Chicago or New York or California who have never heard of an Arkansas small estate affidavit. They don't know what it is. They don't want to spend the time researching and learning about it. And in the end, you get a call back says, well, that may or may not be valid, but we're not going to honor it anyway.
Right. So, I've had that discussion with those national bankers from time to time when I have utilized a probate alternative, such as a small estate affidavit, and I've done everything properly. It's been filed in the proper places. It's been indexed in the county records. I've done everything I'm supposed to do as an attorney representing a family, and that national bank or brokerage firm comes back and says, well, this small estate affidavit is not good enough for us to release these assets. Our policies say, our policy manual says that we have to have a judicial order that determines who the heirs are and says that we can pay that money out. And that can be very frustrating. And
but when you think about it, if you think about it from your own personal standpoint, now realize that like this small estate affidavit, all we're talking about is a piece of paper that has been signed by a couple of people and notarized. Now, it doesn't, anybody can draw up a piece of paper and get anybody else to sign it and say anything they want in that document. So imagine you were the one holding somebody's money. You're in charge of their money, they've died, you're trying to figure out who to give it to. And somebody shows up with just this little simple piece of paper that says they should get it. Now, you don't know this person, you don't know the family dynamics, you don't know if they've lied on this document. You might not necessarily be all that comfortable giving them the money, because if somebody else shows up and they too are entitled to the money, it's going to be your fault. You're the one that's holding the money. You were the one supposed to make sure you did right with it. And that's where these banks come in.
right, and I understand that. It just is. It's a very frustrating process. For an individual and a family if we are talking about a very modest estate.
And the kids and everybody, they get frustrated. They say, look, I'm the only two kids. And but Bank of America doesn't know that.
Yes.
And neither does the title company, and neither does any of these people. Now, of course, all of this is if you're dealing with a small estate, and we've been talking about a small estate affidavit,
Yes.
which basically relates to a situation where there's no will.
Right.
But there are situations where you have a will, but even though you have a will, as we've talked about before on the show, no will is effective unless it's been probated.
Right, unless it's been taken to the court. So we'll take our next break, and when we come back, we'll talk about alternatives to a full probate in the event that we do have a will from the deceased. So stick with us. We'll be right back.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
I'm so glad we found the Wadley Senior Clinic. Their team specializes in caring for older adults, and their doctors listen and work with me to keep me healthy and independent. With monthly educational programs, x-ray and lab, and state-of-the-art exam rooms, I get expert care and understanding about what I'm going through. Best yet, they're easy to get to right off the interstate at Jefferson. See what Wadley Senior Clinic could do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back, everyone, to Aging Insight. I'm Lisa Scholmeyer here with John Ross, and today we're talking about alternatives to a full probate. So we have a situation where a person has passed away, and we need to line out their property and get that taken care of, but maybe you don't want to do a full probate. John, if a deceased person has passed away and they do have a will and it appears to be executed properly and we have an original will with the original signatures, is there some alternatives to a full probate if we have a will?
Yeah, now here, once again, now we have an actual will, but as we said before the break, a will has to be probated before it's any good. Constantly run into situations where somebody's come into the office and they've said, well, I've got mom's will, and so I've been doing this and I've been doing that, and my first question is, have you probated the will? And they'll say no, and I'll say, well, you understand you didn't actually have the power to do any of that. Even though you're the person named as the executor in the will, that doesn't get you there. A court appoints an executor, not a person who makes up a will. Person who makes up a will recommends an executor to the court so that when they die, the court knows who they wanted to be in charge. So you're not really the executor. So no will is effective unless it's been probated. But going through that whole process, again, can be time consuming. So for example, we have something called probate as a muniment of title, which is all just a fancy way of saying that we want to make the will official, but there's no reason to go through all of that big mess. We just need to make the will official. We need to have that deed become a public record so that anybody who wants to know who the deceased person's stuff now belongs to could go to the county courthouse, look at the will, and see in the will who the heirs are. And this is a process that can be over essentially in about a week or so.
That is true, and a couple of cautions when we're talking about using a muniment of title as a probate alternative, or as I like to call it an abbreviated probate. First of all, with the muniment of title and I suppose with the affidavits of small estate, the deceased, we have to be in a situation where the deceased does not owe any money.
Right.
There cannot be any outstanding creditors that are owed money. Those have to be already taken care of by either the beneficiaries or heirs of the estate, or maybe there's none at all, at the time the person died. So that's a big question mark. And, if you've got creditors out there, these abbreviated probate manners are not a way to avoid those creditors.
Right, and a lot of times you'll get the, maybe mom had a house, that was her only asset in the whole world. She had a stroke, she spent the last 2 years of her life in a nursing home. That was paid for by Medicaid because, you can have a home and still qualify for Medicaid, and still get the care you need, paid for by the state. And so the family's like, well, mom didn't have any assets, she just had the house, so she certainly doesn't have any bills. She doesn't, well, not quite, because with Medicaid, you have the Medicaid Estate Recovery Program, which says that the state wants all their money back. And so you do have a creditor out there, you just may not realize it.
Well, that's true. And I know particularly in Arkansas, as soon as someone applies for Medicaid, the DHS, the Department of Human Services in Arkansas, will file a request for notice with the county clerk's office to say, hey, if this patient ever passes away and someone comes to the clerk's office to file a small estate affidavit or a muniment of title or a full probate, we want this clerk to notify the Department of Human Services immediately. And so those processes are already in place, and so any filings, whether it's a probate alternative or a full probate, will be, DHS will be notified.
Right, and you can also run into the same problem with the muniment of title that you run into with a small estate affidavit. Now, with a muniment of title, you do actually have a judge's order. You have a judge who has signed an order that says, yes, this is a valid will, and any of the deceased person's stuff now belongs to these people in this will. So you do have a judicial order. But once again, the concept of doing something like a probate as a muniment of title is foreign to some of these bankers and stuff that are in these foreign jurisdictions like California.
Like California, that's foreign.
That's foreign.
Yes.
Foreign to me. And so you still oftentimes can run into problems. And so you want to be very careful. Although doing something like a muniment of title is going to be a lot less expensive, you're still going to have court costs in the couple of $100. You're still going to need the assistance of attorney, which can cost anywhere from a few hundred to, say $1,500 or $2,500 throughout that process. But you don't want to go through all of that.
Yes, only to find out.
Only to find out that the bank or whoever won't honor that muniment of title, and now you've got to go back and do the whole probate process again.
Right. So if you are dealing with a family member situation where someone has passed away and you feel like their estate is quite modest, you need to get good advice on which direction to go in before you really get started, so you get started on the right path to start out with.
That's right. You don't want to do one thing and then have to redo it
Right.
because you got bad advice along the way. And of course, getting that kind of information is why we're here on the show. It's also why we do our radio program, Aging Insight Radio, which is live every Saturday at noon on 98.7. You can call in and ask questions right there to Lisa and I live on the radio every Saturday. We also have our Aging Insight magazine, which you can find in your local doctor's office, hospitals. You can even come by our office and pick one up. They're complimentary out there. You can even reach us out on Facebook. It's Facebook /Ross and Schollmeyer. We got neat stories and articles on there. Otherwise, stick around until next week and we'll have a new episode for you. See you then.
Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Schollmeyer. This program is made possible by